You know that feeling, right? You walk to the mailbox and you see it, an envelope from your HOA. Your heart kind of sinks. Is it about the trash cans? Is my lawn half an inch too high? Well, today we're diving into a story where one of those letters didn't just cause a little stress, it kicked off an all-out legal war. So let's meet our homeowner, Nathan Brown. He's living in the Val Vista Lakes community, and his story starts with something super common, a notice about some dead plants in his yard. Seems straightforward, right? But believe me, this one little letter sparked a chain of events that ended up with everyone standing in front of a judge.
And check out how fast this all went down. On October 18th, Mr. Brown gets that first letter. Just 6 days later, on the 24th, he's already filed a legal petition. That's fast. The HOA follows up with a more formal notice in November. And by January, boom, they're in a hearing. This thing went from 0 to 60 in no time flat.
Now this is where things get really interesting. Because you see, this case was never actually about the dead plants. Not really. The entire legal battle, all the time and money, it all hinged on one simple question.
Here it is, the big question. Was that initial notice of noncompliance just a friendly heads up? You know, hey, you might want to fix this before it becomes a problem. Or was it an official, legally binding violation notice? The answer to that question would decide everything. It's kind of wild how two parties can look at the exact same piece of paper and see completely different things. On one side, you have Mr. Brown. He's saying, look, this is a violation notice and it's legally defective because you didn't tell me my rights. But the HOA, they're on the other side saying, whoa, hold on. That was just a courtesy letter, a simple warning. Those legal rules don't even apply yet. And this right here, this was the homeowner's Exhibit A. This is the Arizona law he built his entire case on. It basically says that if an HOA is going to take enforcement action, they have to tell the homeowner, in writing, about their right to a hearing. So Mr. Brown's whole argument had nothing to do with landscaping. His claim was about the process. He believed that because the HOA left out this key piece of information, his right to a hearing, they had violated his fundamental rights as a homeowner. All right, so you've got two completely opposite interpretations of the same letter. So what does the law say? How did the judge cut through all this noise and make a decision? Let's get into it. And the verdict was, the judge threw out the homeowner's petition. Case dismissed. But the why is the most important part here, especially for anyone who lives in a community with an HOA, because the judge's reasoning is basically a roadmap for how to handle these disputes. The judge's logic was actually pretty straightforward. It boiled down to a three-step analysis. First, just read the words on the page. Second, apply some common sense to the law. And third, make sure everyone followed the proper steps.
Okay, so step one was a plain reading. The judge pointed out that the letter itself said a formal notice of violation might be coming down the road. The logic here is simple. If the letter is warning you about a future violation, then it can't be the violation notice itself. It's a precursor, a heads up, not the main event.
Then, step two, a sensible interpretation of the law. The judge reasoned that the statute doesn't mean that every single email or letter has to contain this formal legal notice. It just has to be provided before the real enforcement begins, which would typically be with the actual violation notice, not the initial warning. And finally, this was the real kicker. There was a procedural mistake. The law required the homeowner to send a written response to the HOA by certified mail to formally dispute the issue. Mr. Brown, well, he skipped that step entirely and just went straight to filing a lawsuit, and that move really undermined his whole case. So, after all that, what do we take away from this? This whole situation is more than just a story about one person's yard. It's a fantastic lesson for anyone who ever has to interact with their homeowners association. The lessons here are just so clear. First, you have to read every single word. The difference between noncompliance and violation can be huge. You have to understand that a courtesy letter is actually a good thing. It's your chance to fix an issue before it gets serious. And maybe most importantly, you've got to know the rules and follow the procedure. As we saw here, jumping the gun and skipping a step can be a very expensive mistake. When you think about it, this whole mess, the lawyers, the court dates, all of it, it all came down to the specific wording of a single letter and one skipped procedural step. It's a powerful, powerful reminder that when you're dealing with your HOA, the devil isn't just in the details. He pretty much owns the place.